Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on fire. Time for a girl on fire. Time for
Hello, hello, hello. Hello, hello, hello. Firstly, let me apologize because I messed up with the videos for last week. I've been gone a week and I missed you all. Breadhead, that's me. Bill, first of all, congratulations to you and Cindy for your 49th anniversary. That is an incredible achievement, and it actually reminds me a little bit about something I wanted to say before we start in on our regular viewing pleasure. I was away for the last week. I was on a journey. I was on a trip. I was togethering with people. But whilst I was togethering with others, I was missing you guys. While you're not the intended audience and recipients of the knowledge of my trip, you will be unintended byproducts. And each of you influence me, and therefore what I do, in very special ways. So, being gone made me remember exactly why I love being with you guys every day, and I want to appreciate you all for your love and your support and sharing your milestones and sharing the dips. That is what this is all about. Together, we get through things. Beverly is going to be home soon. John met somebody from the chat community today, and he's going to be in 4K. I heard about that. Bill, 49 years. That's an incredible achievement. I'm serious. Congratulations to you and Cindy for not killing each other. I think that has to be said. I like that though. Marriage is a 60-40 partnership. You both have to give 60 and take 40. I've heard it being 100-100. You always have to give 100, you always take, or something like that. I can't remember. But I like Bill's better. Anyways. Yes, 6 of those years were happy. Seriously, I thought about you guys a lot. I spent the week doing incredible things. I'll verify the NDAs that I signed, which were multiple, before I get to tell you all about it. But I just really wanted you to know that each and every one of you was on my mind. And I'm really glad to be back. So, without further ado, and with no tears to be seen... Oh, also, if we've noticed, I didn't gain back all the weight that I lost on my trip, even though I ate delightfully. So we will continue with our journey. Seriously, you guys, I missed y'all really a lot. I barely had time to look at court. I really didn't. I'll be honest, I did something really tough for me this past week. I really tried to rein in my inappropriate comments. I mean, some of them just wrote themselves and I couldn't help it. But I really tried to rein that in. And then I also I didn't mention YouTube. It's not that I don't love you guys. In fact, I love you so much. But it wasn't the purpose of the trip. And so it was something that I didn't talk about constantly, which is something I normally do. I love you all so much. I'm talking about you all the time. Hi, Nigel. Anyways, I love this hat. Guess what? Fucking family be damned. We're going to be doing kitchen streams coming up. It's happening. I'm going to be cooking in the kitchen. We're going to be baking bread. I've become inspired. So get ready for that. I'm thinking Tuesday and Wednesday of next week, we're doing daytime kitchen streams. Okay? So mark that on your calendar. Get ready because we're going to make some amazing things. I think we should start with cinnamon buns. Cinnamon buns. Did I love the East Coast? I fucking loved it. Vermont, Maine, beautiful. Beyond beautiful. I also, for anybody from that area, I was treated incredibly well. Beyond special. And so I got to try a maple creamy. Do you guys know what that is? It's spelled Creemee. Hi, Lindsay. Hi, Space Panda. Anyways, one of the highlights of the trip, a maple creamy, something you can't quite capture the magic of unless you're standing on the hillside of a farm in Vermont under the moon, surrounded by cheese. A dream come true. A pure dream come true for me. Anyways, that's enough. I've been talking enough. 7 minutes. I was late. Oh no, I started at 4:05 on purpose. Wait, did I start early? I started early. Oh my god. We are in a new era. We are in a new era of Paisley. This is incredible. Anyways. I forgot I set it up for 4:05. Oh my goodness. Oh my god. Jesus wept. Anyways, stop it, Paisley. Stop it! I'm amazed. Also, my nails held up. Shout out to the nail girl. Here, look at them closely. They look so good, don't they? Oh, it's so good to be back with my people. With my people who love me. But I guess I want... Oh. Why am I on top of the screen? Also, I want to say, weirdly enough, a tradition that we have here. Oh, Space Panda, welcome. The norm here is me being inappropriate pretty much all the time. My head's in the way of the screen right now. But seriously, I love you guys. Okay, now I've forgotten. Yeah, norm doesn't apply. Bill's got it right. Bill, by the way, when I hit my goal weight, will you make me a new mirror of my pretty face that I can have alongside my little fat face mirror that you made me? I'm terrible, but seriously. Yeah, hair down. Hair's been down. Somebody told me to wear... Oh my. Hi, Casey Carey. Oh my goodness. Oh my goodness. Oh my god. She's got a hair around. That makes me so happy, Bill. I'm still losing weight. I didn't gain back all the weight. I'm really excited about that. I'm going to keep on track. Also, I just want to share one story before we continue. There was a lot of problems with my flight home, to the point where I was on the road an extra day in a city far, far away. And when I got to the airport in the morning, baby, they said, oh no, no way. Your ticket has been canceled, baby. Anyway, so I was back and forth between counters and people at the airport until an angel named Emmy came through my path. She took me to save me and got me home at last. But part of what she did was when she looked at my passport, she gasped. She said, "Oh, you look just like that." I said, "Emmy, you're so sweet. I've had such a shit day. Are you just saying that to get on my good side, baby?" But she said no. It was not just for that. You really do look still just like that. But that picture was 10 years old, so it made me feel great. Anyways, let's watch some court because I can't think of any other rhymes. We're going to small claims court, and we're going to start with, we have 2 cases to watch. Oh, there's a picture of me. I am so vain, so fucking vain.
Do you swear or affirm any testimony you give will be the truth and nothing but the truth?
Yes.
Yes.
Okay. All right. Ms. Bedwell, this is, I'm sorry, I do use.
Yes, that's fine. Yes.
Can you please state the case? I have reviewed the file and some of the evidence. Can you please point out the claim that you're making today?
I am here today to seek the rest of the money that Josh and I agreed to for the business licenses. In 2022, I was going through a divorce and needed to sell my business. This was my sole income. So I reached out to someone. I reached out to Josh to see if he knew anybody that wanted to buy some licenses. And he said he was actually in the market to buy some. He didn't want to move his licenses because they had some debt on them and things he didn't pay. So he didn't want to move those licenses. So we agreed at that time to 20,000 plus a job. And I started working for him. And when he moved his business and got a place in Tacoma, I started working up there and working on moving the licenses. So I had to move my licenses. So he was actually working under my licenses for a year. And then once I was still going through my divorce in 2023, and we needed to write up some information or a document for that divorce. My ex had a lawyer, I did not. And when Josh and I decided that we needed to write up the document, I asked him to write it up so we can give it to the divorce in the divorce. We did put $10,000 on there with the still knowing that we were doing $20,000. Like I said, I didn't have a lawyer and my ex did. So I basically came out of the divorce with just my 2 children. And so my ex-wife received the $10,000 that was on that agreement. Once the divorce went through, Josh's.
Hold on, did she say ex-wife? NPC, hi, baby. Who else came in? Victoria B. Also, Space Panda. You write lyrics, I'm gonna sing them. That's the way, I like it, also, pre-warning, we'll probably go late tonight. Just because I love you. Where's Courtney? Courtney!
My licenses finally cleared in April of 2024. At that time, Josh fired me and hadn't paid until mid-April. when I sent him the invoice for $20,000, and he said that I will pay. And so we have texts and emails going back and forth stating that it was always 20,000. Josh never denied it. He never said that wasn't the case. He always said, yes, I'm getting the money together, I'm paying you. And so, yes, we did have the agreement, but it was an agreement that you couldn't outside communication modify, and that's what we did. If you see in the exhibits, he never denied that it was 20,000.
Okay. I'm looking through. Is there, point me to,
Beverly. I just want to say you've been so inspiring to me lately, and I've been telling your story, and I love you so much. And I'm so proud of you, how hard you've been working at getting yourself better. I don't think it's often acknowledged when you get sick that you need to work really hard on it. And you've been working so hard, and we are all so proud of you. So you take all the time you need, but just know that I love you so much.
the specific document that, or any exhibits that address, so I'm looking at the emails now. Oops, switch her sideways. Okay, there we go. The emails. So the email I have is from you. Is there a response from him agreeing to the 20,000?
Yes.
Which one is that?
So on, let's see, there's the one that says, agreed, that you agreed 20,000 are not paid in 30 days. And he writes, there's one that says, do you want the licenses back? And I said, yes, but then that never happened. And then there's also the other one, Exhibit D, I believe,
Okay,
that says, the total left is 16,000. And he says, Jody, I am paying you. I have been paying you. And then there is text also that say the exact same thing.
okay,
And there's the other one too. I even gave Josh 3 options to pay. The one
Right.
you paid.
I did see that one.
Okay. And never did he deny. He just said, thank you for setting these options for me.
Okay,
And then if you look into the text, it's the same.
okay. Okay, anything else to add? And I'll talk to Mr. Haney next. Said anything else? Rita?
Okay, we
No,
can. I've realized
Right,
we can only. Shut up, Judge. Wait. Oh, Paisley's feeling sassy. Anyways, I realized that we can only do the kitchen streams during the day. You're gonna change your name for Halloween. I love it, Beverly. I approve 100%. I think something that we have in spades is culture around here. Each and every one of us bring a little bit of culture from our own lives to each other, and sometimes we adopt it. I'm remarking about F in the chat for the hat, something that we picked up, but also many other things. And I am feeling sassy. The sun came up, babies wet their diapers, and Bill was on fucking fire. As usual, I love it. I love you guys so much. I've missed you so much. You won't even know.
Mr. Haney, is it okay if you call you Mr. Haney?
Yes.
Okay, all right. So you've just heard what Ms. Bedwell has to say. Can I hear from you now?
Yes, the contract was submitted by her. She took it off of the internet I did not write up the contract. The contract has, all changes need to be submitted in writing. My responses to her was as civil and as short as possible, as per asked to be by my lawyer, who's a friend of mine. So all contact with her was short and never agreed to anything or disagreed with anything. We had a contract that was reviewed by the state.
What a lawyer move. Don't agree with anything or disagree with anything. I will straddle the line, but never get any dick inside me. Inappropriate. Again, why I suppressed so much of myself, because these things just bubble forth. I can't help it. 5 days is my max, by the way. Do not let me go on a work trip longer than that ever again. Ever again. Ever again. Ever.
And that was the purchase price of 10,000.
Correct. That money was deposited in her account as quickly as I could get it in. The delay of transfer was caused by her divorce, not by anything I could have done. And I kept her employed as long as I could. And I left. I did not have when she was no longer employed, I did not have work coming into the license at the moment, or the work. So I mean, nobody was employed besides me, which, I mean, I'm the owner, so I wasn't getting paid. I've since then built the business up, but you know.
Judge, I also heard him specifically.
I'll let you respond in just a second, okay?
Okay,
All
sorry.
right, anything else? Anything else, Mr. Haney?
I have a contract.
Okay. And so just in looking, you can alter contracts. Do you have any response to I guess the emails and things setting out the amounts being different than $10,000?
I did not agree to the amount was different than 10,000. I just said I would pay her, which meant I would pay her the contract. That's what I was referring to. In nowhere did I say, yes, I owe that much money.
Last night I pulled more.
Okay. Ms. Bedwell, your response?
I did overhear him tell someone right before he did fire me that he was just waiting for the licenses to go through and then I was going to be fired.
Okay. So the problem I have here is, do you have anything in writing that confirms he agreed to 20,000?
Just the emails and texts that he never denied. He never said in there, yes, it's just 10,000 to the contract. Never did he say that. If he didn't agree with it, why would he say, I am paying you, I will pay you multiple times?
So the issue is not whether or not he's going to pay you. The issue is the amount of money. And so you've got a written contract for $10,000. It looks like actually two, because there's two different agreements I see.
And a bill of sale, Your Honor.
Okay.
And then that was also submitted to the state. And we.
I know, Bill. If my boss saw me dancing like this, she'd be like, bitch, I should have scheduled you for today. I gave you the day off. Honestly, though, the reality about that is that I slept 9 hours today and 9 hours yesterday. And barely anything the previous 5 days. So, you know. But yeah, I bounce back really easy. I love to bounce. Let's just say that. and I got to do 0 bouncing on that trip. Tell me whenever else I've got on a plane and never bounced upon some.
We both had to submit through DocuSign to the state the amount of money.
Which Josh did to not pay as much taxes.
Yeah, unfortunately, I have nothing here, and I have a dispute between 2 individuals regarding the amount of the contract. I have a written contract, which is definitely evidence that confirms the amount of $10,000. And I have text messages and emails that are not conclusive as to what the amount of the contract is. And based upon the evidence I have, I can't find sufficient evidence that the agreed amount was $20,000. So I am going to have to deny your request.
All right, thank you.
Denied! Big D in the house! Also, you know that jet lag is no match for me, baby. People were like, oh my god, it's so difficult for you. And I was just like, we power through. Maybe it's my age. I don't think it is. I was not the youngest, but I made it through. Billy, thank you for asking. The trip was amazing. Sorry, NPC. I love it. I think part of me didn't adjust to the East Coast on purpose because I'm a late bird anyways, and so I just stayed up really late. Everybody else went to bed and I walked in the cities that we were in. Oh, they really did? That's so stupid, NPC. I'll talk to YouTube Daddy about that. I got an in with daddies lately. But, I walked. Actually, here's a funny interlude story before we move on to our next case. Giving Courtney a moment to appear and say, next case. Anyways, we returned to our hotel very late at night. But of course, that doesn't give me a fright. I decided I would go. I was in Portland, Maine. That's right. And I decided, thank you, Beverly. Thank you. Scratching that itch for me. I love it. But I was in Portland, Maine, and the lady from the hotel, I said, hey, is there a 7-Eleven around here? And she said, yeah, there sure is. She said, you go left and up the hill, and you'll see it. It's not too far. And I thought, okay, great. So at 11 o'clock at night, I went left and up the hill. And I started up the hill and I got myself a chill. And I didn't know what was going on till I got to the top of the hill. And she had sent me through a cemetery without telling me. I was a little bit thrown off. Courtney, thank God you're here. Beverly stepped in, but if you could say next case, we'll be there. Anyways, so she sent me through a cemetery to get to the 7-Eleven. Also, last little story, I was at a 7-Eleven. They were blaring opera music. Blaring opera music. And I loved it. The second I hear it, I begin to dance, as I always do when there is music. I'm dancing my way into this parking lot, and these 2 guys in this truck are like, hello, and I'm like, hello, wow, you got great music. And they looked at me like I was crazy, and they were like, oh, you're like the only person in the world that likes it. And I was like, oh, well, I do like it. I think it's a pretty good jam. And then I went inside. I bought myself some Red Bulls because they didn't have rock stars. And then I walked my ass back through the cemetery, around the port in the beautiful city of Portland, Maine. Absolutely gorgeous. Would go back again. 10 out of 10 would recommend.
Is there anything more that I need to do, or can I leave the Zoom?
No, I'm gonna sign the order and you can leave the Zoom.
And you don't get to leave because we got
Thank you, Your
another
Honor.
case. And I want to know
Welcome.
if you
Have a
guys
good
think
day.
this guy's a lawyer or not. We have a very famous cemetery near my house, and somebody wrote a book about it. And it impacted me immensely. Anyways, Judge, what is going on? She tipped the computer. You see this? She's tipped the computer down. Ridiculous. Ridiculous.
And there's no other one ready now.
Ridiculous. Judge, do you not know how this works? Ma'am? Ma'am? Your high school yearbook photo was taken in a cemetery? I sort of love that. The school I went to is like a cemetery because it was like 112 years old. So, you know, death becomes them. Anyways, let's watch Thurston. Let's watch it now. We got to slow it down.
Mr. Hodges,
Half. Oh, I said one. Let's go with half.
can you please go through your claim for me?
Half. Judge.
Yes. My former tenants left the rental house in just disastrous condition.
Phil, you're killing me.
They left the house damaged. I've listed multiple ways in which it was damaged. They left the house extremely dirty, failed to clean it to any kind of livable standard. I spent over $17,000 rehabilitating the house, getting it back to the point where I could rent it. Hired a contractor who also hired multiple subcontractors to bring it back to a livable condition. There was extensive wall damage, which is documented in photos by the subcontractor who repaired the damage and then had to paint the whole house. There were mildew issues that were caused, according to the contractor, by the tenants and their lifestyle. I mentioned cleaning. I provided photographs of the necessity to hire professional cleaners after they left. I have significant landlord hours, which are chargeable at, I think it's $45 or $50 an hour. I have an electrician charge, which by lease is the tenant's responsibility. And then I have July rent, which I believe is owed to me. They vacated early. We had a verbal agreement that they would not have to pay July rent if they performed in certain ways, which they did not. And that included leaving the house undamaged, leaving the house clean, not leaving stuff behind, trash behind, that sort of thing. All of that's been documented. So those are the highlights. In my filing of evidence, I have a number of receipts that kind of prove the points and the damage. I have the move-in photos from when they started renting the property. I have the lease that's in effect, which documents a lot of their responsibilities that they did not follow through on. So this is my attempt to recover at least some of the expenses that I incurred in order to re-rent the property.
Okay. And let me see, the lease I'm looking through the original documents. I see lots.
Okay, before we hear from the other side, first of all, I love you guys so much. Space Panda, his mic does suck. Also, he sucks, is what I'm going to go out on a limb and say. Secondly, Tay's auditors, they have a mildew lifestyle. That's what he really tries to promote here. Living on the West Coast, mildew lifestyle is not your fault. It's wet here. And I'm not just talking about my pussy, okay? Anyways, also, what was I gonna say? I want you guys to tell me if you think that the respondent in this matter, the man, is a lawyer. Because I think he is. I knew Courtney was wet, but you know what? Just like me, always, baby, always.
And lots of photos. Can you point to me where you have a copy of the lease? I think it might be in Mr.
Yeah,
Harris's.
it's a section, I think it's under section 2. I think it's marked section 2. Let me look. I've got the paper right in front of me. Yeah, it is it starts on page number.
Vicky is taking a little break from live chats of YouTube, but she is watching always, still commenting more than you. No offense, that wasn't directed just at Lisa. That was at everybody. But, no offense, but Vicky is still schooling most of you on comments. There's a challenge. You want to give me a Christmas gift without spending a single dime? Comment on every fucking video from here till then. I will specifically send you a Christmas card if you do that. You got proof of that? You send me your address, I will send you a Christmas card on my dime. You understand?
I numbered the pages by hand in the upper right-hand corner. It starts on page number 1, and it says original lease referenced in all extensions.
I'm counting on it, Erica. I've actually set aside a Christmas budget this year for sending Christmas cards. Did I say Erica properly? Probably not. My brain's fucked up right now. But please do go down the rabbit hole. I love it. I love it. I'll gladly spend a toonie on postage.
Okay, now I'm gonna hear for a minute from Mr. Harris and Miss Campbell, or do you go by Miss pronouns? Okay, I just want to make sure. So I don't know how you want to present this, because it sounds like you have a kind of counterclaim that is a separate claim. Is that correct?
It's necessarily separate, Your Honor, mainly because the issue of him coming after us for damages is necessarily separate to the security deposit claim that we're making. Mr. Hodges has full right to come after us for anything that he perceives as damage, but he has a statutory obligation if he wants to utilize our security deposit funds for that. That's why it's necessarily a separate case.
Okay, so why don't you start by responding to his claim?
Yes, Your Honor. Savannah has a statement she'd like to share, and then I can get into some of the legal details if that's okay.
Okay. I know that this.
Hold on, let's make this an official challenge with a command. If you write a comment on every video that we do between now, October the 3rd, 2025, and let's say December 1st, 2025, because I'll have to send them out ahead of time, you will indeed win yourself a Christmas card that I will send out anywhere in the world. Probably a mistake as I say it, but it's true, baby. I will indeed send that Christmas card out because honestly, I love you guys. Periods don't count? Probably not. Well, once a month you can send out a period. John, what I said is if you comment on every video between now and December 1st, I will send you a Christmas card. Oh, don't edit the command. No, that doesn't need to be edited. But we'll set up a spot on Discord. Anyways, send one to Zimbabwe for you. Honestly, I already have a list of people to send Christmas cards to this year. Zimbabwe would not be crazy.
Court is not based on emotion and it's based on fact. But I would just like to share that reading Mr. Hodges' filing felt deeply personal and humiliating for me. Mrs. Freese's statements on the state of my home being a health and safety hazard was a blatant mischaracterization of the state of my home, which caused intense lingering anxiety for me. Upon looking at Bob's own filing online, his own personal pictures show that most of the hazards that Mrs. Freese pointed to were pre-existing conditions. Both of her statements made me question myself and my abilities as a mother. And it's now a public record how Mrs. Freese feels about us as parents and people when none of that is based in fact. Additionally, having an ESA in my rental was specifically to help me manage my anxiety levels. And having Bob drop off a threatening note at the door to our new home felt incredibly threatening to me personally, and then triggered intense panic that I felt was done specifically to intimidate us into paying it. I loved that house. We made it a home, and I'm sad my memories there are always going to be overshadowed by this claim against us. I would like this to be resolved today so that we can move forward and celebrate our new home instead of mourning the memories of our old one. Thank you, Your Honor.
Okay. And since you're giving a statement, can you confirm how long you guys were there?
5 years, Your Honor.
Slightly just under 5 years, Your Honor. About 4 years, 11 months, 12 months.
And as it relates to the condition of the house after you left, I'm looking. Yeah, why don't you just, I'll hear from you now.
There's a preliminary issue I'd like to address first, Your Honor, and you can find it in my filing on page 4. Number one, the preliminary issue is that Mr. Hodges failed to service properly. He never sent us the service packet. He signed his own certificate of service. He did not hire a process server or send a letter. That's one of the first issues that we have here today, is that Mr. Hodges just failed to service properly. How we want to proceed based off of that is up to you. But that's the preliminary issue I'd like to discuss with you now.
Yeah, I think that issue has been waived just by the fact that services has to do with notice, and you have clearly received notice, so.
Okay, that's completely fine.
Yeah.
I understand that. The other thing that we'd like to bring up is first, and kind of going through this in piecemeal is relatively difficult, Your Honor, because of just the kind of nature of this filing. There's pictures that aren't associated with proper claims. It's kind of just a dumping of evidence and invoices. So I've done my best to go through it and try to give the court an idea of what he's reasonably trying to charge us for. The number one issue that we can start with is that on the first page of his filing where he goes through costs, he, number one, doesn't have really any itemization of these costs. He has miscellaneous for $230, which goes against the very foundation of the Residential Landlord-Tenant Act. He does not have hours associated with any of these charges. He also has charges that are on this invoice for items that were clearly purchased after he already had new renters in the building. You can see that through the various appliance diagnostic, the McKinley's appliance, and the Walgreens photo, which all were handwritten after the filing was made. There's also, as it relates to the landlord hours, and we can see this in my filing as well, that there is no itemization as far as what took what amount of time, why he's owed $50 an hour, why that's actually reasonable to market rates for a landlord, which the RCW requires him to do. And beyond all of that, Your Honor, in RCW 59.18.280, it clearly states that he can't charge us for the full replacement of any items. And throughout this entire filing, he's charging us for full replacement of whether it's an appliance, whether it's drywall in the home, whether it's paint, and he doesn't associate any of the damages that he purports to take pictures of with any of these claims. And so the court and Savannah and I are left kind of wondering what these charges are necessarily for and why they have to be associated with us as tenants.
GMO cookies
Beyond that,
ringing in at a whopping 30.3%. What does my hat stand for? Bread? It says bread and it stands for bread. This is from King Arthur Flour Company. If you do a little research, you might find out that the King Arthur Flour Company is in Vermont. I'm pretty sure. She says that not knowing. Yes, John, I strike a fine balance between monetizing this channel and allowing free expression. We don't censor people around here. We don't block people. Really, we really don't. Sometimes it makes life a little bit hard, and I appreciate you all understanding that. But that's the way, I like it. So that's the way it will be. We have not. Please stop trying, Lisa. I need this money. Has cellulite yoga pants found a workaround? Also, I'm not married. Erica's just getting divorced. Give her some time. It took me 7 years to get divorced. All right? Never divorced from reality, just from the asshole before.
The most fundamental issue in the case is that Mr. Hodges never had a signed move-in checklist. We never agreed to any kind of condition that the home was in prior to moving in. As a result, most of the damages, if not all of them, we report are prior from when we moved into the home. And you can even look at Mr. Hodges' own checklist that he provides that's unsigned. And in that checklist, there are contradictions that Mr. Hodges makes throughout the filing. The fact that he says that we couldn't put in contact paper when his checklist clearly states that contact paper was already installed, where he said that we had holes and minor wear and tear to the walls that required an entire replacement of all drywall. When in his own checklist, it states that there were holes and nicks on the walls. His contractor is blaming us for moisture in the bathroom because of a rusty door handle and making wild inferences as far as how those would actually be caused, when in reality, his own checklist states that the shower already had rust on the actual rod. And so we are just left wondering, number one, how Mr. Hodges is making a connection between why the way that we lived in our house and ultimately how that's causing damage. Number two, he has completely failed in his obligation to provide us with a full and specific list with invoices that are susceptible to market rates. And most importantly, when we talk about the good faith nature of this filing, which is required by the Residential Landlord Tenant Act under RCW 280.18.260, it talks about the fact that he has to come in and with good faith argumentation, which he fails to do. This 746 electrician charge is a great example of it. That can be found, let's see here on what page. And I can just pull up the invoice, Your Honor, if you can't necessarily find it, but it's an invoice for $746 for a complaint that apparently was unfounded. There are no hours associated with this invoice. Beyond that, how, if somebody wasn't fixing anything at a home, how in any idea we could be invoiced for $700 as a standard service charge? That doesn't make any sense. And if we're paying at an hourly rate, the average hourly rate of an electrician is $45 an hour, and Mr. Rogers is charging us for $800 here without any explanation of where this money is coming from, how many hours this electrician worked, what they were necessarily looking at. And that is indicative of the entire filing, Your Honor. All of these are invoices for the entire amount of full items without going through any kind of depreciation calculation. The pictures that Mr. Hodges provides are only showing at most wear and tear.
Honestly, Space Panda, he really is. Also, I'm dancing along because I fucking miss you guys so much. Just being able to deal with serious shit while also dancing around. I appreciate you all. But I actually think he's a lawyer, or he's in a field where he presents facts to people that are important a lot. It is hard to nail down this type of speech, and he has it nailed down. This is a better presentation than we get from some lawyers. Actually, I would argue 50%. So I think Bill might be right. Like, what I'm talking about is somebody who's prepared to give fucking facts and hard numbers in front of somebody who's higher up than them, who's gonna make a decision about it without faltering or meandering. And that's what he's doing. It's kind of sexy.
And Mr. Hodges also provides pictures that have no bearing on any of the actual arguments that he makes. Now, on his point of us owing rent because he apparently did not leave the lease or meet our lease terms, we can look to his own email in his filing that he sent to us, where on page 11, I'm sorry, Your Honor, just bear with me here. But in his own
Say that page
filing,
number,
he sends
babe.
an email on page 12 that delineates what our responsibilities would be in order not to be charged July rent. And those were paying for lawn maintenance, which we did. That invoice is included as a part of my filing. The second condition was being out of the home and allowing contractors to work in the home, which we did. By May 13th, we were allowing full use of the unit for anybody to make any relevant repairs they need to make. And then we needed to be out by June 7th and pay the entire month of rent for June, which we did. As a result, Mr. Hodges was able to get new renters into the building by July 15th. So we just find that the premise that we completely failed to meet our obligation when he was able to get renters in just over a month, we find to be made in bad faith, Your Honor. We don't think that that's true. And beyond that, we've met all the obligations we were supposed to meet. So having us be responsible for July rent is simply, it's an undue burden in our opinion. But there is a lot more that I could say, Your Honor. This filing is 97 pages long, and it includes invoices that aren't associated with any of the argumentation that he's making. And he's asking the court and myself to basically go through this entire document to delineate what I should and shouldn't pay, when in reality that goes against the very foundation.
Can he say delineate one more time? Did he just say it's 97 pages? Holy shit. Talk about no life. Who do you think, what's gonna happen? Who do you think is gonna win this case?
Foundation of the Residential Landlord Tenant Act, which makes it very clear that in order to try to balance out the scales of power between landlords and tenants, they need to be incredibly specific about why they're keeping our deposit and why they're charging us for these exuberant amounts. And ultimately, Mr. Hodges is seeking $10,000 in reimbursement. He has $18,000 in charges here, and it's completely unclear in terms of what out of that 18,000 he's actually trying to reasonably get access to in this court. And it makes it very difficult for us as prior tenants to come to any determination about what we should or shouldn't pay, just because of the nature of the filing.
Mr. Hodges, I'm going to give you a chance to respond, but I want to ask something real quick. I can't find that. These are all photos. Okay.
YouTube Daddy, if you wouldn't take me down for the music, I would be able to play it while we listen.
His exhibit. Because if you look in here, these are all photos. Every one of them is a photo. They don't include like.
Is anybody surprised that nobody's walked behind her yet?
Yeah, let me take a look at this. Mr. Hodges, I'm having trouble accessing your filing, and so Mr. Harris here has brought me a copy, his copy of it.
What a pro alpha move. You want to be a pro alpha? You want to be a pro alpha? I'll teach you how in court. Bring paper. Bring so much paper that everybody can have a copy. Can you even imagine? Do you know what he's doing? I should do that game, Space Panda. We've sort of done that before, but we should do it still. But seriously, did he print out 96 pages times multiple? Oh, do you know what kind of ink budget you have to print out 96 pages? Holy shit.
But do you have any objection to me looking through this?
No, not at all. It was filed with the court, accepted by the court. I'm not sure why you don't have access to it, but it was both paper and digital.
Okay. Well, I'm gonna look through this just real quick. So it's under 3939260.
Yeah.
And then it says plaintiff and defendant exhibits. And when
Plaintiff.
I do that, and then
Hold on, did he just fart? I'm such a lady. I was listening to a song and dancing, but I'm pretty sure he just farted. I mean, what? Like, Courtney, I think that's actually what happened. Look at his face. We're going to go back 20 seconds. I know it's too far. But together, look how close he is. And then he's going to back away. He's going to be so close and then back away. I love you guys so much. We have so much fun. Could you think of anything you'd rather be doing on a Friday night?
With the court, accepted by the court. I'm not sure why you don't have access to it, but it was both paper and digital.
okay. Well, I'm gonna look through this just real quick. So it's under 3939260.
Yeah.
And then it says plaintiff and
Oh, it's him
defendant
putting the glass
exhibits.
down. But, sir, it still
then-
sounds like a fart.
And I do that, and then, oh, I see what you're saying, there. There,
Yeah.
okay.
Also, judges are so notorious for not knowing anything about Ted.
List of all the photos. Okay, there we go. All right, let me look through this real quick. Okay, now that I have this open, Mr. Hodges, do you want to go through any specific response to anything Mr. Harris said?
He referenced an unsigned checklist at the start of the lease, which was he worked with Green property managers on that. I provided photos from their checklist. I don't know, signed or unsigned. I don't know whether there was another page that was signatures or not, but that came from Green Property Management. That was part of the lease that they signed. So the documentation of the condition of the house was there. That documentation does reference some minor issues in the house, but they were extremely minor. And I think if the tenants were honest about it, that they were extremely happy with the condition of the house, and the house was, I would characterize as like new. I do want to reference the statement that Ms. Campbell made. First of all, I'm really sorry that she has experienced some emotional trauma over the situation. I don't wish that on anyone, and I'm just really sorry she's experiencing that. I do feel like this situation that the tenants need to take responsibility for their part in this situation, but that doesn't mitigate the fact that that her feelings are hurt and that it has caused her anxiety. And I'm sorry that she's experiencing that. I have spent a lot of time documenting the issues which are in my filing of evidence. I collected as many receipts as I could. I collected narratives from contractor and subcontractors and the cleaning people I think I have 90 some photos of the situation that I was left with. I really feel like I've documented more than sufficiently the condition of the house that I received from the tenants when they vacated. Um, the tenants talked about the July rent issue, which I acknowledged in my own filing. I told them that if they performed, if they did the things that were in the lease and that we had agreed to verbally, that's fine. I would not charge them for July, but they didn't do that. And I referenced multiple issues in my filing that they didn't do. The lease speaks to many of those issues, which I'm happy to go through with you, but they just didn't perform, and that cost me a lot of time and a lot of money, and that really is the purpose of my asking for damages.
Yeah, one second though, before you respond. So Mr. Hodges, you're asking for a lot of money. Can you give me, just kind of walk me through the breakdown of what you're seeking?
I'm sure I can. Just a second.
Money, 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 money.
This is in here.
Bread. Money, 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 money.
So if you look on page 1 of section 1, section 1, page 1, that shows final accounting.
Right.
There's a list, a real specific list of damages and receipts. There is also a page 2A, which was my initial accounting, which the tenants referenced that I had delivered some threatening note of some sort to their new home. That was not the case. This page was what I delivered to their home to give them a heads up that it was, this is the preliminary accounting, this is what I'm working on, and that there would be more to come. It took quite some time to to fix everything and to figure out, who we were going to hire and who was going to do what work.
Landlords don't just get to charge everything to fucking tenants, though. Sir, get over it. Hi, Adam. Hi, baby. Oh my god, Hathead is real. I used to think Hathead was a joke. Hathead is real. Oh my gosh. Oh my gosh, it looks sort of cute, like a skew. I just don't know if I can pull that off. I don't know. I don't know. I don't know. I don't know. I'm so glad to be back, Adam. If you missed it, I almost cried at the beginning. Like a little bitch. Oh yeah, somebody asked for me to wear it backwards earlier. Yeah. Actually, that's cute. Let's keep it like that for a little while.
Reason that there was both a preliminary and a final accounting. I don't know if I'm answering your question properly, but on page 1, there's a list of charges, and they're pretty specific. The tenants reference something about the landlord hours. I I was very specific, 18.5 hours at $50 an hour. I'm willing to change that to $45 an hour because I think that's
$50 an hour? Sir! 50? You can go get fucked! Sorry, but what are you fucking talking about? $50 an hour to stand there with your dick out like, oh shit, it looks messy in here. Oh my god.
reference in the lease. That would change that number from $925 to $832.50. But you can see clearly I listed a lot of things that I needed to do So I'm not sure why that would be called not specific. So does that list satisfy your question? Does that answer your question?
Well, in a way. I mean, so let me, I'm kind of going through the list here.
Uh-huh.
What, in your opinion, was the cause of the mold issues and the water damage issues?
Lifestyle. So I worked with a contractor on that who also hired several subcontractors, and that was the conclusion.
It ain't 50, but your heart is there. NPC, the fact that you're here, your support over the years, thank you so much. It means the world. Seriously. $5 means just as much as 50. That's the truth. Because $5, baby. Well, you used to be able to get a sub, a $5 foot long. No longer. But I still love you, baby. Thank you so much.
I mentioned, I think I mentioned in the attempt to mitigate that the tenants during the 5 years that they were there lived with the windows shut. Apparently, I know that the blinds were down every time that I drove by the house or came by the house. There
Looks
was
at
no
blinds
attempt.
that are currently down. Like, yeah, fuck face. Why are you driving by my house looking through my windows? No wonder my fucking blinds are down. Creeper? That doesn't cause mildew, bro. Your shitty house does. Maybe take some responsibility for that. Have you ever had a lease that says that you have to open the windows? That's inappropriate. Get the fuck out of my business. If I want to keep the windows absolutely closed the entire time. Bill, $4.90. 49 years, you and Cindy. I aspire. I'd have to get down to business, Bill. I'm not gonna lie. I'm not gonna mince words. You understand? I would have to get down to some quick business to manage 49 years. But I'm proud of you for doing it. Thank you so much.
Apparently at to increase airflow or to run fans and that sort of thing. And that caused a significant mildew issue. At one point in time, I came to the house on another matter, and I noticed that there was some discoloring of the paint on
It's
some
his
of the walls in the
anniversary,
house.
Adam. 49-year anniversary. I can make it to 49 years old. Jesus. I fucking hope so. Knock on some wood. I'm just kidding. 49 years anniversary. Much harder feat to match than 49 years old. Oh, fuck. Jesus Christ. I'm almost 50 already. That's right. Throwback to that episode. Oh, fuck me. I love you guys so much.
And the tenant and I discussed, what's going on here. I asked them if they knew what was going on, and I guessed at a couple things, but I didn't know what was going on either. I asked them if they wanted me to repaint or to, mitigate the dark spots on the walls, and they said no. As it turned out, that issue, the mildew issue, which I believe they caused, and then the extensive but small wall damage. There's small bits of wall damage all over the house. That then caused me to have to hire a subcontractor to repair the wall damage and to repaint.
Let me just ask Mr. Harris and Ms. Campbell about the offer to mitigate dark spots on the wall. Did that happen?
No.
Was there any complaints about issues with the house during your tenure there? What kinds of issues were you having?
Correct, Your Honor. We reference in our filing under exhibit, and let me find that here. Just have to find. Yes, that's exhibit A, where we talk about moisture and stud staining communications in our response. That which should be on page 37 and 38. In that exhibit, we clearly show how we had communication with Mr. Hodges about the dark stain on the walls in 2022 and 2023. Mr. Hodges also sent out a subcontractor named Scott to take a look at the dark staining in 2022. Over the course of our tenancy, obviously the stains would get darker, but Mr. Hodges never offered to, hey, do you want me to repaint? Do you want me to do redo all of the sheetrock in here? That conversation never happened. And if it had, even if it had, Your Honor, and we had said no, that doesn't give Mr. Hodges the right to then charge us for that entire repair after we leave our tenancy, and instead to utilize standard wear and tear photos as the reasoning for why that repair had to happen. Even in his contractor's own invoice, she references how the correction for the moisture in the walls for the darkening of the studs would be repainting and redoing the sheetrock. And Mr. Hodges did not engage in that repair while we were still tenants. If he had, and then he had come to this court saying, hey, I repainted and redid all the sheetrock in the home in 2022 because of this issue, and now they're leaving with all of these holes and minor scuffs and scratches, then maybe there'd be an argument there. But as it currently stands, we reported that issue years ago. He never addressed it, and now he's looking for post-judicial relief, at least in our opinion, as far as payment and correction of that particular issue. Now, beyond that, Mr. Hodges also says that he has statements from cleaners and subcontractors in his filing. That is, I can't find any evidence of that other than the singular testimony of his one subcontractor named Haley Fries. In our filing, we have an entire page dedicated to why that response is. Simply put, I mean, I've never received an invoice like that, Your Honor. I think any tenant who would receive an invoice for repairs where the predication of the invoice is based off of complete baseless assumptions of the tenant's lifestyle would find that to be not only offensive, but I mean, going against the complete foundation of the RCW, which is to provide a full and specific list. And the invoices that he provides are filled with social commentary about different generalizations about how we live our lives. And all of this stems after he sent us communications saying that we were going to be his adversary. That is what my wife, Savannah, is referencing when she talks about the threatening letter that he dropped off on our door. And you can find that in my 3926 filing, which should be present inside of the current, where on the last page we go through not only the text messages that Mr. Hodges sent saying that we are now his adversary and he's going to come after us, but also the note that he left on our front door as an exhibit. Now, all of that, when we take it in conjunction with the email that he sent his own contractor on May 13th in his filing, where he dictates, these are all the things that I saw in the house. Did you find anything else? And she says, no, other than the garbage disposal. That email shows all of the things that he saw when he first came in to take a look at the home in May when we gave him early notice of leaving the home. After the adversarial communications, and you can see this in the timeline that I attached in my filing as well, that is when all of a sudden we owe $11,000. All of a sudden we owe $17,000. And all of it is predicated off the testimony of one individual who is basing all of her information on us off of seeing our house in a state of disarray while we're trying to move after being there for 5 years. And there's a lot more that we could respond to in Mr. Hodges' filing, Your Honor. My response is 76 pages alone. So there's a lot of stuff that I try to consolidate in that filing to make it very clear what Mr. Hodges is trying to come after us for. That's why I include the price point. That's why I also include the evidentiary timeline. But that is, again, my best attempt at trying to reason all of these potential charges. And We just feel that it's completely unclear. But if you have specific questions about any of the charges that Mr. Hodges is reporting or our response to them, I'm happy to talk through it if you wish.
Okay. Well, I want to give Mr. Hodges an opportunity to respond. It's a little back and forth because I'm trying to make sure you both cover kind of the issues that are here. But Mr. Hodges, did you want to respond to what Mr. Harris said?
Sure. I'm sorry, I just don't agree with the tenants. I did offer to mitigate the whatever dark spots that were on the paint years ago. That was verbal, but I did offer to take care of it. It actually bothered me. I felt it bothered me more than it bothered them. When I made that offer, they did not want to do that because they said that it would provide upheaval for their family. They might have to move out or move stuff. So I don't know what to do other than say that, yes, verbally, I did offer to fix it. In some regards, I'm glad we didn't because it would have just happened again based on how they kept the house so tightly shut up. Then the tenants reference a list that I included in my evidence from May. And that's true. That's why they hadn't even moved out yet. That is what we found preliminarily in May. I didn't have access to go over the house that early. When they finally did move out, I think it was June 7th or June 8th. That's when we had access to really figure out what we were going to need to do to rehabilitate the house. So that preliminary list, yeah, absolutely, but that was not any kind of a final determination. They didn't move out till June 7, and that's when we were able to understand better the extensive damage and need to rehabilitate.
In their tenure there, which it sounds like it was approximately 5 years, did you do periodic inspections of the property?
Occasional. Obviously now I wish I had done more, but it would be anecdotal, probably at least a couple times a year, if not a little more. I would stop by to check to see if everything's okay. I would check that via text and email with the tenants as well. If something like needed a new garbage disposal or there was any kind of issue in the house, I would get that fixed immediately. And that would give me the opportunity to, kind of survey the house.
Prior to this inspection that you did, it looks like after they had moved out, had there been working exhaust fans throughout the house?
Yes, 4 of them.
Were they found to be in functioning order when they moved out?
Yes.
So what the fuck?
All
That
right,
don't
I'm
make
going to let
sense.
Mr. Harris respond to that.
Yes, Your Honor. We agree that we use exhaust fans all the time. I think that's clear from the photos that Mr. Hodges provided. I don't see how mildew gets into a fan if it's not consistently used. While we didn't check the inside of the fan, I think it's very clear that the house had a moisture problem prior to us moving in based off of the checklist that Mr. Hodges provides that shows rust in the bathroom on the door handle. His own inspector doesn't even reference that checklist in relation to making us responsible for the rust that's in the bathroom. Beyond that, Mr. Hodges, we believe clearly is not approaching this in a good faith effort in terms of trying to understand what we would reasonably owe him. I mean, the most important part about it is that we have no way of determining what the functioning life of any of the items in the home are in terms of what we would actually owe back. He's charging us for the full replacement of every single item that's on this list. He doesn't go through any kind of calculation to determine what the reasonable life of the items would be, particularly because we lived in the house for 5 years. And to Mr. Hodges' point of saying that I offered to fix it, even if he by his own admission just now, he literally says, I'm glad I didn't because the problem would have simply persisted. If that were associated with any kind of lifestyle change that we would have needed to make, then Mr. Hodges, that would have been his first suggestion to us when he saw the darkening. He would have said, hey, Mr. Harrison, Mr. Campbell, and Ms. Campbell, it looks like we have darkening in the house. Why are all the shades drawn down and why is there so much moisture in here? That seems to be the cause of this. And then we would then change that lifestyle. But clearly he never had that conversation because that wasn't an actual issue in the home. We didn't have mildew everywhere. The house wasn't moist at all times. And the idea that because there's moisture existing behind a wall, that is immediately associated with something that we did and not what could be going on in the attic, what could be going on behind the wall, what could be going on the siding on the outside of the house. I mean, there's a myriad of different reasons why there could be moisture in the walls. And Mr. Hodges didn't reference any kind of change in behavior when he came to check on that, nor did he offer to fix it. And even if he had, he would still, even if he had, there would still be present wear and tear in the home, and we wouldn't be able to be charged for that. And he would still be responsible for addressing that particular fix monetarily, whether we're still in the house or not.
All right, okay, so here's what I'm gonna do. Mr. Hodges, I'm gonna give you one last chance to respond on the issue of the claims you're making, and then I'm going to briefly hear from Mr. Harris on the claims he's making against you. Okay, so, do you want to respond on anything he just said?
Yes, do you want me to respond on what he just said, and or do you want me to provide a summary of all the stuff?
Both as quickly as you can.
Okay. So Mr. Harris said something about that I should have, I guess, advised them to change their behavior or change their lifestyle or whatever. That's not my responsibility as a landlord. In fact, it would, I think, just cause more anxiety and angst on their part. But that's really not my role to tell them to change their lives or lifestyle. The problem, we're just kind of focused on one small thing, but it was a very expensive fix. But the problem with mildew in the house, there was no problem for 10 years prior to them moving in. And there's been no problem for 6 months or however long it's been since they moved out. The problem was when they were there. And there wasn't, like I said, there wasn't a before, there wasn't an after problem. Mr. Harris referenced the shower rod in one of the bathrooms had a little bit of rust on it. And I don't know about the doorknob, but that type of a problem is caused just naturally by water in the shower. It's not that is not indicative of a bigger problem in a house. And I totally that's fine if they want to not pay for replacing the shower rod, perfectly okay. But that's not the big picture. The big picture is the fact that I had to repair and replace the sheetrock throughout the entire house. I provided lots of photos that showed the subcontractor going through the house and putting blue tape up all over the house. In some rooms, there were 25 or 30 marks on the walls that needed to be mitigated before painting. So those are really two different situations. Again, just a really brief summary. I have provided to the court the move-in photos that would show the good condition of the property before they moved in. I provided the lease. We haven't really had the opportunity to discuss the lease. The lease shows multiple places multiple things that were the tenant's responsibility that they did not follow through on. And if you want, I'm happy to go through that. I provided over 100 photos that were taken after the tenants left that showed damage to appliances, damage to the walls. That showed how incredibly dirty the house was when they left it. It showed trash that was left that I had to take to the dump. So like I said, I've tried really hard to not be emotional and just show the things that as they were when I had to rehabilitate the house. I think it's really clear in the documentary evidence that I provided what the house looked like when they left and what my expenses were, shown in the receipts and the list of damage.
Right. All right, thank you. All right, Mr. Harris, before I rule on this, because they're kind of connected issues, do you want to provide your claims that you're making against Mr. Hodges?
In relation to the security deposit, Your Honor?
That's your separate one that's under cause number 39261.
Yes, Your Honor.
Yes,
Could I-
yes,
could I
yes.
interject for just-
Hold on! Stop interrupting, Bob. You notice how I was just fucking quiet for a minute? I danced my little heart out. Okay? You see? And yet, Bob, you have to speak. It's not going to help you. It's not going to behoove you to do that. You need to learn to shut the fuck up. Long coming, Bob. Let me tell you. Anyways, I guess let's hear what the counterclaim is, and then we'll see. Also, Courtney, your internet could be fine. I could just be looking like a bad dancer, just because I am a bad dancer. Bill. Fuck, you make me laugh so much. Well, Adam, welcome back. By the way, cooking in the kitchen next week in the daytime, Tuesday and Wednesday. Be on the lookout. I'm going to be wearing a pretty cool outfit. Maybe that's nothing but an apron. Maybe. Also, somebody on this trip asked me, do you ever get anxiety? And I was just like, no. Like, not about talking in public or like talking to people. It's not really a problem for me. I don't know, we're gonna bake cinnamon buns. That's what we're gonna bake. Baking while baked. Ooh, that's the title. Can somebody remind me of that? Baking while baked? I'm pretty sure that is the title of our show. Woo!
Second?
Yeah.
So I don't know about this claim. I have never been served. I haven't seen anything about this claim at all. So I'm a little bit at a disadvantage.
Your Honor, the nature of the claim is whether or not we can withhold, whether he can withhold the security deposit and whether he would be owed to double damages for this court's purview. And the last time that I came into court on September 5th, the presiding judge in my case, 39261, stated that because Mr. Hodges has a myriad of different addresses in the state of Washington and he hadn't responded to any of the certified mail filings that I had made to the two other addresses that he provided to court, that I would like to serve him over email or electronically. The judge in that case said, that is fine. We will allow him to serve you. You allow to serve him over email. All you have to do is include information showing that he opened the email. That way I know that Mr. Hodges actually saw it. And that's exactly what I included in my certificate of service. I had a separate individual send the email from their email account. There's a mail tracker associated with it. It shows that Mr. Hodges opened the email. He read the email. So that's why we have the certificate of service in the case of us today.
Okay, if I could respond to that, that is not true. First of all, I travel quite a bit. I was out of the country for most of the last month or so. I did receive 2 emails from an address that unfamiliar to me. I literally just noticed them a couple of days ago. I did not open them, so there's no way you're going to provide proof that I opened them. And I still don't know to this point what's in those emails.
Your Honor, there's a mail tracker associated with it. He opened the email.
Okay, well, I'm gonna hear from Mr. Harris because you're both here today. I'll give you a chance to respond. You'll be able to hear from him, and then I'll make a decision after we hear what the information. Go ahead, Mr. Harris.
Well, Your Honor, in terms of my case, it is very simple. If we look at our evidentiary timeline, we can see that At the moment that we stop responding to Mr. Hodges' text message after the relationship, by his own admission, becomes incredibly adversarial, that is at the point when all of these charges skyrocket in terms of what they would necessarily, what we would have to owe. But beyond that, the most important part of this filing is three main arguments. Number one, Mr. Hodges has a statutory
We're on
deadline
our
to
way
provide us
out
with
as
a fair-
soon as this case gets ruled on, Hector. But thank you so much for being here. We are going to get a ruling tonight, and then we will say adios, baby. But guess what? Before you leave, put yourself down for a date tomorrow night. That's right, Saturday night. Let's do it, you and me, baby. Tomorrow night, probably like 6 Pacific, which is 9 East. Who knows what time zone I'll be on? The fucking kicker will be how much caffeine has Paisley had? / taurine / vodka. No. That's right.
Specific list of any of the issues inside of the home. He failed to meet that statutory deadline. He did not provide us with a clear and specific list of the damages. He doesn't make an argument in a response to this filing, but he does mention in his own filing that he ran out of time to provide, to actually get us access to any of these numbers, when in reality, every single invoice that Mr. Hodges includes in his filing, other than the purchases that he made after he had new tenants in the actual unit, all of those invoices come before July 7th, every single one. The only other invoice that wasn't available to Mr. Hodges prior to the 7th was his blind invoice, which is ordering an item online off of Lowe's that doesn't have any kind of labor associated with it beyond the fact that we have to order a physical item. And we can talk about why we shouldn't necessarily have to pay for that on a different date based off of the photos we provide. But as it stands, Mr. Hodges failed to give us a complete and full and specific list within 30 days. He did not provide us with a signed move-in checklist as a part of that list to dictate why he would be charging us certain items. He is charging us for clear wear and tear violations, and he took more of a security deposit than he was statutorily allowed to. On top of everything, we just believe that Mr. Hodges has approached this whole process in just incredible bad faith. I mean, the fact that we paid all of June, left a month early, gave him 2 additional months to take a look at the home, and he wants to use that as reasoning as to why we would necessarily have to pay him even more money because it's a preliminary check, I think is very indicative of the actual response to the filing itself. But we feel our filing is very clear in terms of all the different things that Mr. Hodges necessarily did to violate the law. And as a result, we feel that we should be entitled to our entire security deposit amount and double damages if the court finds that as well.
And so what's the specific amount? I think I wrote it down.
The specific amount was, I believe, $3,600 or 3560, which is totally fine. And if the court would feel it within our right to afford us double, that would be fantastic. But we understand if that's not the case.
Okay. All right, Mr. Hodges, did you hear what they're claiming here?
I did hear that.
Okay. How would you like to respond?
First of all, let's talk about RCW 59.18.280. In my filing, I noted that in that RCW, it clearly gives the landlord the opportunity to show that circumstances beyond my control prevented me from providing the statement and documentation within 30 days. This situation is exactly what that statutory language speaks to. It took us a tremendous amount of time to figure out how to mitigate all the situation and all the damages that the tenant took. There was no way that we could do that job prior to, I don't know when he might have expected it, but the end of the lease wasn't even until the end of July. So I would have had till 30 days after the end of the lease. But even if you count from the time that they vacated, there was not enough time to rehabilitate the house and understand all the damage in that 30 days. That's why that statutory language is in there to provide some protection in these egregious circumstances. The tenant said something about that I ran out of time. I really don't understand what that's talking about, that I had 2 additional months to look at the home. That's just not true. They vacated the house on June 7th and left it in a horrendous condition. And that that's the first time that I had an opportunity to start the actual work on the house, to start driving stuff to the dump, that sort of thing. So I just, given the statutory language in the RCW, I think clearly that the timeline that I followed was legitimate. Again, clearly the lease didn't end till July 31. So that's how I feel about those specific charges.
Okay,
In response, yeah, Mary, respond to that.
you can respond.
If you look at my exhibits inside of my filing, you can see that Mr. Hodges' contractor started work at the property on May 19th, looking over the attic, doing work in the property. That gives Mr. Hodges over 50 days to delineate any additional damages that would be associated with the house. Beyond that, if you look at my other exhibit inside of my filing, which is exhibit on page 22 in the filing for 39261, Mr. Hodges states on June 9th, 3 days after we left the property, that he was ready to show it. It's just, it doesn't make sense to us in relation to how there could be $1,000 cleaning charge. I had to take an additional month to understand how much more damage is in the property, when in that same month, he had a person view the house 2 days after we left. And then beyond that, he also has, he has individuals that are under contract on the 15th of July. We left on the 7th and he already had people under contract a month later. Like the premise that he didn't have enough time to tell us what we needed to specifically pay for by July 8th, mainly because none of his invoices are after that date. All of the work that he was doing, he was able to get done significantly prior to that date. And then beyond that, the house was ready to show on June 9th, according to his own admission in his text. So we just, again, Your Honor, we feel as though he has flooded us in this court with a myriad of different items that we are now left to put the puzzles together for. And that's all.
Okay, I'm ready to make a ruling, and there's a reason why I had these 2.
Hold on, Judge. Before you do, I was already deep in thought about something else, and you surprised me. So, what I was thinking is the only thing I'm missing after my trip is a debrief with another adult, like a nice dinner. But, in the meantime, Judge, what do you have to say? What are you going to tell us? Everybody, oh, you didn't watch any fake shows? I appreciate you, NPC. I missed you guys so much. If you want to see me almost cry or shed a tear or two, go back to the beginning of the video. But who do we think's going to win? What do we think's going to happen? Is she going to split the baby in the bathwater? What will we see? Quite a case. Quite a case.
Cases kind of overlapping and hearing together, and obviously they are connected. I told you at the beginning, it's very helpful to use DRC because it's likely that neither one of you are going to like what I'm going to do here. But as I see it, and I'll start with your motion or your claim, Mr. Harris, is it seems to me to be a sad situation where you rented this place for an extended period of time, and it seemed like the relationship was good for a very long time, and then it wasn't right here at the end. there is sufficient evidence to support that the house was left fairly messy, that you left before the lease was up. And so I don't, and that there was a walkthrough done in May that showed sufficient things that needed to be corrected that would dictate the non-return of your security deposit. So first start, I'm going to deny your claim on claim number 39261. Okay, now to address 39260, this is where Mr. Hodges isn't going to like what I have to say. I don't believe there's sufficient evidence to support that the mildew damage was caused by your tenants and not some other condition. I do believe that a lot of these photos and a lot of the work that was done is normal wear and tear on the premises. As I just stated to Mr. Harris and Ms. Campbell, though, you have provided sufficient evidence that it was left in a state of disrepair and that you are entitled to retain the security deposit. However, the additional claims beyond that, I believe, are excessive and not supported by the evidence. And so I am going to agree that it was okay for you to retain the security deposit, but I'm going to deny your claim for additional amounts of money. And since I've denied
Wow.
both of your claims, I'm not going to award either one of you return of your filing fees or services.
A
Okay?
little bit of a big D.
All right, so I'm going to fill those out. We're done, and those
Bill, you
orders will
called
be
it.
available later online.
Thank you, Your Honor. Appreciate it.
You're not looking forward to your company, Lisa? That sucks. You know what, guys? I'm looking forward to my company, which is you guys being my company. You want to come over? You want to come hang out at my house? We have a lot of fun here. I'm exceptionally fun. I'm not kidding. I am fun, and I require very little sleep to have this much energy all the... Who the fuck is honking? But, alas, I do have to exchange my goods for services tomorrow, so I will be busy during the day, but I'll be back at you tomorrow night. Back at it again, and then you know what? Space Panda has inspired me to do a special members only on Sunday. A little guess what she's listening to kind of vibe. That's exciting. Anyways, do me a favor in the meantime, remember to hit the like button, leave a comment. Remember the challenge. If you would like a Christmas card from me, you're gonna have to work for it, baby. That means you're going to have to go ahead and write a comment on all the videos I post between now and then, all the live streams I do. John's going live later. He's got a 4K video camera. You've been warned. You've been warned. I will take no further responsibility for that. In the meantime, remember that I love you and I'm proud of you. I really am. Super proud of you guys. Just like you're proud of me. I'm proud of you. And I will see you in the next video. Okay, bye. I said bye.
Ways down, ready to ride.